One of our subscribers posed a great question to me today. Can a civil case lead to criminal charges? So you've been sued civilly and it's over damages. Say you've been sued for fraud or bad business dealings or breach of contract. How might that lead to a criminal case? So far you haven't been charged criminally. But you see, what happens in a lawsuit, there's what's called a discovery process. Each side has to give all of their documents in their possession that are relevant to the case. And you're also subject to what's called an examination for discoveries. Well, that's under oath. So during this process, it might uncover all sorts of evidence that incriminate you. And the other side can then go to the police. It becomes a public record. The police can discover it. And the police may feel there's reasonable probable grounds to charge you with a criminal offense. So yes, civil charges can lead to criminal charges, and it's a very dangerous thing. So whatever you disclose to the other side may become a public record, and you have to disclose everything. Those are the rules in a civil case. It's full discovery. Each side has to give the other side all their documents, and you're subject to discovery. So that discovery is an examination of discovery. And there's a problem with that too. You see, now you're under oath, so you may be making certain admissions. Now, you do have the protection of what's called the Canada Evidence Act. Under Section 13 of the Canada Evidence Act, if you incriminate yourself, let's say, as a crazy example, an examination for discovery, you admit you murdered one. That's the truth, and you admit it, and they've got proof of that. Now, Section 13 says, if you are charged criminally, the Crown cannot use that admission to prove that you did the murder. Now, they may have independent evidence that you did the murder, though, and charge you. What can they use that under oath statement from the discovery for? Well, they can use, and this gets complicated, you're going to talk about all other sorts of facts during that discovery. They can use the non-incriminating parts of it to cross-examine you at your criminal trial. Section 13 only protects the admission that I did the murder. It doesn't protect all the little nitty-gritty details, for example, of other things you might have done that day. So for example, let's say you testify at your criminal trial and you say something inconsistent with what you said at the examination for discovery in the civil case. Well, the Crown can cross-examine you on that as long as it's not a criminal admission. It gets complicated, but it's hard to keep people's story straight, even whether you're lying or telling the truth. If you've testified once in a proceeding and 2 years later you're testifying in a criminal proceeding, it's very difficult for even the most truthful witness to get their story straight. So the short answer here and the bottom line is civil cases often do lead to criminal charges. You have to be very careful in this regard. You should consult with a criminal lawyer within your proceedings as well. Make sure you hire a good civil lawyer as well to protect you, to make sure you're properly prepared for examination for discovery and getting the documents to the other side that you need to. So there you have it. That's the bottom line. Yes, civil charges can and often do lead to criminal charges. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.